Alex Wasswa. Alex Wasswa mufumbiro right here in the court of Nakawa Magistrate. From here to much India. Go together much India.
Jina yako eneo
The other code is procedural as before, and recommendation remains as before.
The first considered as before. One addition.
Generally,
Now we adjourn for purposes of receiving the ruling, the bail application. The applicant, we are ready to receive it. You're obliged. So ruling is ready. So the applicant, through his team of lawyers, applied for bail on 3rd November 2025 when he appeared in court and produced three sureties, who included the father, wife, and the area member of parliament, who is also a friend, the applicant. All their particulars were exhibited in court, that is the national IDs, their national IDs and their introductory letters from their area of residence. The state made a request, have time to verify the letters which that had been presented, which request was granted, and the matter was adjourned today for the state to reply and the consideration of bail. Today, the state has made his response to the application for bail and largely objecting to the grant of bail to the applicant on numerous grounds, which I will point out here below in this ruling. However, the state had no objection to the suitability of the sureties that were presented by the applicant. On court evaluation of all the three sureties, they are considered to be responsible citizens of the high standing in the society, and in that respect, I agree with the defense counsel and find all the three sureties substantial. So this takes me to the objection raised by the state attorney, which included the nature of the offense, the gravity of the offense, severity of the punishment upon conviction against the applicant, the accused being faced with other charges in Kawempe Chief Magistrate's Court, the likelihood of the applicant interfering with the witnesses, and the matter being of public importance, among other things. The state invited the court to deny the application, but in alternative, and in the likely event that the court declines to grant the accused person bail, he invited the court to set stringent terms that would compel the accused person appear in court for trial. And he cited various authorities and provisions of the Constitution of the Republic of Uganda, particularly Article 23, 6A, Section 77 of the Magistrates Court Act, the Constitution, bail guidelines for courts of judicature, practice direction of 2021, with regulations thereunder. And they were all taken into consideration. In rejoinder, the defense team, led by Counsel Samuel Muizi Mulindwa, vehemently put us by one, which I will not reproduce here. However, considered in this their full effect. And he also supplied authorities to buttress his argument, which I also considered. This court is alive to the fact that the accused person has a right to apply for bail, and he is presumed, or which is a presumption of innocence, and in reference to 20, and that is in reference to Article 28 of the Republic of Uganda. And this court is also aware that the quest for is quest for personal liberty. I need also to note that as ably submitted by both the state and the council, grounds of the grant of bail are clearly laid out. This will be against the public interest in the provisions of Section 77 of the Penal Code, which submission was refuted by the defense in rejoinder, but it is not, that submission is not supported by any evidence and thus therefore remains speculative. I wish to note that the charges against the accused person as submitted by the state are indeed serious, mostly when they are committed by the person I beg your pardon, as it has a serious effect on the general public, which causes fear and panic amongst the members of the public. Therefore, such an offense is against the public interest. In the instant case, so as to where the accused has other offenses in other courts, I would agree with the defense team that each case is handled on its peculiar facts. And since the case is still ongoing, the case referred to is still ongoing, it cannot be used to impute character on the applicant. And as if the applicant or as if the applicant has had a conviction on those matters. I believe the provision cited was misconstrued. As to the likelihood of the applicant interfering with witnesses, the state indicated to court that investigations in this matter are ongoing and that the applicant interfere with witnesses if released. And given the way the offense was committed, he would have access, according to the state, he would have access to the platforms which he used to commit the said offense. And that submission was refuted by the defense for reasons that no witness or materials were supplied to court, were shown to court to guarantee the interference, and invited court to disregard such an objection and grant the accused person bail. I wish to note that indeed, as highlighted by the state, the investigations are still ongoing. And given the status of the applicant in the society, being a deputy spokesperson of the lead opposition party in Uganda, with command and respect, and means, in my view, he would interfere with investigations and there would be witnesses. So in order to preserve the integrity of the investigations and public confidence in justice, it would only be fair that the accused is temporarily remains in custody to pave way for speedy investigations and for justice to be seen to be done. Therefore, considering the submissions of the defense team, the response by the state, the application, the rejoinder, and having considered the law, the nature of the offense with which the accused is charged of, its gravity, the status of the investigations, the effect of the offense on the society, and having considered the balance of interest between the applicant's right and the public, I decline to grant the accused person bail, but rather advise him to reapply when investigations are complete and consequently direct that the state expedites investigations. I so order.
Your Honor, we seek an indulgence.
Yes.
And clarity on the timeline, on time limitation within which no one's going to get that. Because
Yeah.
it can't be open-ended.
You seek for?
The guideline on the timeline.
What does the law say? So in the meantime, the matter is adjourned to.
Your worship, our worry is,
Yes.
since you've been categorically clear that you can only grant bail after the closure of investigations. We want
Your objection.
No, I'm still submitting. I'm speaking audience, of course. Yes. Your worship, our concern is.
Yes, I think let's observe decorum.
Yes.
We speak one at a time.
Most of right.
Yes. State. Can we hear from him?
Yes. Your worship, how we construed your advice that actually you only entertain his bail application after Saturday finished with
No.
investigation. So I wanted at least to advise, or if you may, indulge the state to expedite the
That's why.
investigation.
That's what I've done. That's what. That's
Because
what
they
I've
may
done.
investigate forever.
It
Yet
can't
the
be.
man
There is a
to
test of
campaign.
reasonableness. We can't investigate forever.
Most of them.
And at that, in that regard, the court will raise it
Most of them.
at an appropriate time because it is an order. So we can have.
Your Honor, perhaps before, when can we access a typed copy?
You will get it end of this week. Yes. End of the week is ending tomorrow. In the course of next week, you can have it. So we can have. Second December.
It's available, Your Worship. That's Friday.
Yes. I'm having some.
Start with the stage because we had the Tuesdays early.
I have two studies. One on Thursday, another one on Thursday and Tuesday, and he appears on Thursday. So since the matter is still at this stage, the other one, if he's not there, the other one will be there.
Let's take it.
That's right.
No, good stuff.
You can come and start it.
So the accused is trial 1 and 2 then. And the matter is adjourned 2nd December 2025 at 9. For further mention, and the accused is in money until then.
Freedom comes to those who fight, not to those who cry. Yeah.
Council, we have a court. No, can we have lunch?
Freedom comes to those who fight, not to those who cry. Turi mumenyi w'amateka,
Let
ndi
the
mulwanirizi w'amateka.
Sharajan. Just
Satisfied. Bail is granted as said we satisfied all grounds of law and fact. And then going ahead to deny bail is unprecedented. I think it's now becoming a habit in political cases. We first saw this in Kizza Besiege's case, where the judge said all grounds precedent to granting bail have been satisfied. The sureties are substantial, without a doubt. On all grounds, you had that counsel for the defense managed in rejoinder to show that there was no evidence behind any of the submissions by the state. But you go ahead to state that you cannot release a person simply because investigations are ongoing. What we know, like any lawyer would know, that is the ground for granting bail. You cannot keep a person in prison for the weaknesses of the state. The state cannot lie back on an investigation because, for starters, before the state prefers a charge, it ought to have investigated. You do not come to court without investigating a matter and use the same ground to deny a person, but it's unprecedented. But well, these are politically instigated matters. The decision is equally as political as the charge itself. So we are not surprised, but come back. There's a condition in the ruling that once investigations have been concluded, there will be no reason to deny him bail. If the court is to stand by its decision, we shall be here soon to ensure that the Honorable Wasswa Mufumbiro is granted bail.
Legally, the magistrate seemed to bend towards two particular grounds, one being for the seriousness of the nature of the offense, and the other being for the balance of the right of the applicant and the public interest. I would love to have you comment on that particularly.
That was a political decision that since someone is a leader, it means leaders of political parties will never be granted bail. Once there is an allegation against them, it will not be. If it was a court of record, it won't be a good precedent. That by you merely having influence in society, you'll be denied bail. Actually, the purpose of bail is that a person would answer or come for trial whenever they are required. You would know where to find such a person, and that such a person cannot easily do what? Abscond. Simple. These are basic things. but that the law is being now interpreted the other way around because of politics. That is where our problem is. You cannot say because someone is a politician, several politicians have been granted bail. Is no exception. If that is to be the precedent, we've seen people on charges of murder, aggravated robbery, being granted bail. That's why I said all grounds precedent was satisfied. The court is on record to have stated so. The presumption of innocence. You cannot state the gravity of an offense, then you would be wishing away the presumption of innocence. Is presumed innocent until proved otherwise. The magistrate has put it on record that that was a flimsy and misconception by the state. It is on record. Then you turn the same flimsy ground to deny bail. I think there has been incoherence in the decision. We shall, as officers of court, accept the decision, but we cannot respect it. It has a lot of inconsistency.
Counsel, you seemed to want the magistrate to give timelines with regard to expediting the process of investigations, and the magistrate seemed non-committal about the timeline issue. What's your comment on that?
Well, I think these people are independent. It goes back to the same thing. The judiciary should stand out clear because the court has the power to supervise the state. You cannot leave it in reasonableness, like he stated. What is reasonable? What would be reasonable to the state will not be reasonable to us. So you cannot leave it open-ended. I don't think they are free people. The judiciary is not free from the arms of the state.
Counsel, as you said that you're
ndowooza ekitongole ekiramuzi tekyetengeredde kubanga byogedde tebikwatagana n'amateeka. Mu mateeka ensalawo egambye nti nno bonna abazze okweyimirira Honorable Mufumbiro bali substantial. Ekigendererwa ky'okukuta omuntu kakalu ka kooti nti buli wanaaba bamuyise mu kooti okwewozaako ajja kujja yeeyanjule. Ate bw'aba teyeeyanjudde abamemba ba paalamenti abajja, taata we yajja, mukyala we yajja, abo basobola okusibibwa. Kati discretion ya kooti kwe kuweyinga nti ku musango nga guno gw'okukuma omuliro mu bantu, omuntu asobola okukkiriza taata we bamusibe, MP asobola okukkiriza bamusibe, alina ku bwa Lord Mayor, omukyala asobola okukkiriza mukyala we asibibwe. Kati ekyo kwesinziira nti ono omuntu ayinza obutakomawo. Obuvunaanyizibwa kooti bw'erina ku byeyogedde kwe kuteekawo obukwakkulizo. Eza n'omugamba nti sebo oli mwogezi wa kibiina nga bweyogedde, naye kati mu bbanga lino toyogera. Eryo ebbeetu eririna, bwe buyinza bw'erina. Kyekyo wakitugamba kooti bwe zigaana okweyambisa obuyinza bwayo zigenda mu byobufuzi nga kooti eno gyeraze kya bulabe. Okulingiza okulaba wayinga omukulembeze w'NUP nti kyekyo waki omummi. Amateeka tegamanyi kkala. Decision ebadde clear nti olw'okuba oli mwogezi wa kibiina ekye-NUP nti ekitegeeza oli wa bulabe osobola okuleetera abantu okubeera nga bakola ensobi olw'okumenya amateeka. Kati awo amateeka gaba gatandise okufuna kkala. Amateeka tegamanyi NUP, tegamanyi ekibiina kirala, gamanyi muntu ali mu maaso gaago. Honorable Wasswa Mufumbiro alina kutwitingibwa nga ye byasobola okukola ng'omuntu ne basobola omukugira okukola. So tulowooza ensala newankubadde nga bannamateeka tugisaamu okukitiibwa, kooti ye tugiwadde ekitiibwa, naye tetukkiriziganya nayo. Nkyamu era kooti bwe zinaagenda mu maaso bwe ziti okubeera ng'esobola okugamba nti mu mateeka obukwakkulizo bwonna mu mateeka mubutuukiriza, naye omuntu tetumukkiriza olw'okuba gavumenti erina okugenda mu maaso ng'ekyanoonyereza. Ekisooka kikyamu era kitugamba ne DPP omupya, enkola y'okutwalanga abantu mu kooti temwetegese. Ne mugamba nti ate mweyambise kooti ebawa obudde okunoonyereza. Toyinza kunoonyereza ng'omuntu omaze omuleeta mu kooti. Okunoonyereza kwe kusooka n'osalawo nti omuntu by'onoonyerezaako bisaanidde ye okwewozaako n'olyoka omuleeta mu kooti. Kati oyinza kweyambisa bufu bwa state Olw'okuba nti ereeta abantu ne bakasukwa mu kkooti nga teneetegeka ate ogaana omuntu omutta olw'obunafu bwa state. Kikolwa kya butiitiizi eri ekitongole ekiramuzi n'abalamuzi, kikolwa kya kumalawo ddembe ly'abantu eriwaweebwa constitution nga bwe twabagambye. Omuntu oyinza muggyako liberty mu byakusaagasaaga bya nnambalujega ng'ebyo olw'okuba gwe tosobola kunoonyereza, tukulinde paka lw'onaamala okunoonyereza okuli endless. Tugezezzaako ko tugisaba nti erina obuyinza obulagira state mu mbeera eyo ku ngeri gy'eyinza okutambulamu n'obudde. N'otya kkooti n'etya okulagira state ku ngeri ki gy'erina okukola emirimu gyayo. Kikola kya butiitiizi, kikola kya bunafu. Ekitongole ekiramuzi kyandijje mu buwambe ne kiweereza bannayuganda ne kiraba Wasswa mufumbiro nga bwe twogedde nga ye ekitamulaba ng'abalala abantu bonna bonna. Kimusalidde omusango nga tekinamuwuliriza nti asobola okuba ow'obulabe. Okugamba nti wa bulabe mu bantu nga tonnaba kuwuliriza musango gwe oba omusalidde omusango nga tananakuwoza, kya bwewussa, kimenya n'amateeka ga kkooti. Tugenda kwongera mu maaso okukola ebyaffe bye tukola nga bannamateeka. Tujja kujja mu kkooti tuwulirize abantu baffe, naye baleke okuteekawo embeera abantu nti bajja kulekeraawo kutrustinga kkooti. Twakalembekereza akaliwo kwe bantu okulowooza nti Wasswa teyazza musango kubanga tebannagumusingiza asobola okuva ebweru. Naye kati ako bwe kanaggwaawo, bannamateeka tukyaba tukyalina omulimu ogujja wano, abantu bajja kuba nga balina okutwalira amateeka mu ngalo zaabwe. Sirowooza nti nno ekyo judiciary kyeyagala.
Okay, really, everything council byogedde, but one, as we have said severally, this is political persecution. This particular charge of incitement to commit an offense was an afterthought. You remember when Wasswa was abducted, the way he was taken to Kawempe Magistrates Court in Kanyanya, they said that this one for unlawful drilling. Yes, they allege he committed. That day, Wasswa was not even at Kavule. Never mind that we insist there's no offense that was committed by those who were singing songs and marching around and so on. But Wasswa was not present. So they thought this one might not sustain it. Let it remain on the books, but let's think of something else. That's when now they said, let's bring him here and think of some kind of offense. Since Wasswa, as deputy spokesperson of NUP, is always speaking out, different fora about poor service delivery, bad governance, corruption, and so on. So they said, now let's bring up a case of incitement of the population. Really, that's what they're doing. And that's why court is saying, no, you are a deputy spokesperson of the leading opposition party. We shall not release you to continue to go out there and speak about the bad governance in this country. Never mind that court has agreed that the sureties are all very substantial. They are weighty enough to compel him to return to court and so on and so forth. But court said, no, let's keep holding on to this person. It's political persecution. They know he's in the race for Nakawa East Member of Parliament. They probably think when they keep him there, he will not be able to campaign. He will not be able to go and do the work that he ought to do. But they'll be in for a shock. Good enough, Wasswa is strong, and he has told us, keep pressing on, because this is persecution, it's what it is, but let's keep pressing on. We who are available are going to campaign for Wasswa, and he's going to win with a landslide victory. So let them not think that this is in any way going to stand in his way. Now tuze tukyogera lunye nti kuno si mateeka kye tuyita prosecution. Bino bya bufuzi kye tuyita persecution, kubanga Wasswa baamuwambira e Kawempe nga baamuwamba ne bamutwala mu kooti eyo nga wayiseewo ennaku. Yaga nti kakati ono yali omu ku abo abaali e Kavule nga bakola dduyiro gwe bayita dduyiro ow'ekinnamagye. Naye baamaliza ne balaba nti n'olwo olunaku Wasswa teyaliko Kavule. Ndoza ne balaba nti kino tujja sobola kisustaininga. Musango kale gusigalewo naye tuyiyeeyo omulala kwe kumuleeta wano. Nakawa nti kakati Wasswa ono engeri gy'abeera ku zi radio, ku zi TV platforms ez'enjawulo ng'ayogera kufuga bbi, ku buli yake, poor service delivery n'ebirala ebikyamu gavumenti byekola, baga kati tumuteekeko omusango ogw'okukuma omuliro mu bantu era gwe baamuteekako wano. Ekyomukisa omulungi nti Wasswa mugumu era nga bwe mumulabye agambye nti kitalina musango, tusigale nga tukola kye tulina okukola. Wasswa yeesimbyewo kubeera omu wa Nakawa East. luza basuubira nti banaamusigaza eyo mu kkomera tajja kusobola campaigninga ajja kunafuwa n'ebirala ekyo tekigenda kubeerawo. Wayiso tugenda mu campaigningira kirungi abantu ba Nakawa East bamanyi nti bamulanga bwemage ate agenda kuwangula ate awangulire eddala waggulu nnyo. Eryo essuubi tulirina kubanga talina musango. Kansabe substantial surety onayogera eddakiika emu.
For the first time, eh?
Sebo jangu. Here in the middle.
I do want to appreciate God because I've been a surety. And for the first time, I've been qualified as substantial. I know this is a ploy of government to deny Wasswa Mufumbiro access to his voters, to his constituents, so that he can fail. But I want to make this clear that Wasswa is going to be the next member of parliament. Today we are beginning these rallies. We are going to put all the effort to make sure that Wasswa becomes that eligible member of parliament representing Nakawa East constituency in the Parliament of Uganda. Thank you. Akagendereddwamu okulaba nti Wasswa tafuna mukisa kusisinkana bamulonda era nga Loopu bw'ayogedde. Naye njagala okutegeeza mwe n'abatuuliza n'abatulaba nti Wasswa wetuli era leero tutandika laalize okulaba nti Wasswa afuuka omubaka parliament agenda okunzija mu kifo. Era kkiriza obagaana tutaddewo embeera yonna okulaba nti Wasswa yalangirirwa. Ekyo Loopu akyogedde era kitugenda okutuukiriza. Njagala okwebaza abo bonna bataddeyo support Wasswa afuna obwenkanya. Kyannaku nti kano kakodo ka gavumenti naye tujja kabiiti. Katonda b'omukisa. Olwaleero nebaza Katonda nti leero bannangiridde nga waliwo akagamba katuufu substan mu Luganda kintu ku Luganda omuyima. Njagala okwebaza Katonda nti leero kooti ezudde nti ndi wa muzinzi okusobola okweyimirira Wasswa era sibadde nzekka wamu ne mukyala we ne taata we. Kale nekyo tukyebaza nti tebadde ensonga omulundi oguddako tujja kujja ate mu maanyi ag'enjawulo okulaba nti Wasswa tuddeyo naye.